First of all, thank you to the Chair for the invitation to speak. My role is to explain what the Constitution currently says about the dissolution of Dáil Éireann and about the timing of general elections. The question of who has the power to dissolve the Parliament is a critical question of constitutional design. I just want to explain the significance of the power for a minute. Essentially, and it might seem obvious, the power is significant because with the power to dissolve Parliament comes the power to control the timing of general elections. And the power to do that, the power to control the timing of general elections, has an important effect on the balance of power in political systems, which is something I believe the political scientists will explain in greater detail. In particular, where that power is vested in the leader of government, in the Prime Minister or the Taoiseach, that will tend to enhance the power of and the influence of that figure in the political system, perhaps to an undesirable degree. And so the question of constitutional design, if you like, the question is how that power might be moderated, how it might be checked or limited. There are two major alternative mechanisms by which we might limit or check the power that comes with the power to dissolve Parliament or advise a dissolution of Parliament. The first option is to legally fix the parliamentary term, to take away from a figure like a Prime Minister the discretion to advise a dissolution, to cause or to trigger a so-called snap election. An alternative would be to give some power of veto or refusal or oversight to another authority, such as a president, who might refuse or veto, so to speak, the advice of the Prime Minister to dissolve the Parliament, thus triggering a general election. And if I could summarise very briefly at the outset, the position in Ireland is that there is no fixed parliamentary term. The Taoiseach has the power to advise a general election before the expiry of the maximum term. The power is usually without limit, except in very limited circumstances where the President may refuse the advice and effectively veto the calling of an early general election, but that power has never formally been used and hasn't tended to be a significant feature of our political system. Okay, so what does the Constitution currently say about the term of Dáil Éireann? Article 16, Section 5 says that the same Dáil Éireann shall not continue for a longer period than 7 years from the date of its first meeting. A shorter period may be fixed by law. And a shorter period is fixed by law. The period that is fixed is 5 years. The same Dáil shall not continue for a longer period than 5 years from the date of its first meeting, not from the date of the last general election, but from the date of the first meeting, which may be up to 30 days later. So technically there may be up to 5 years and 30 days between general elections. So what the Constitution does is to allow the Oireachtas itself to fix the term of Dáil Éireann within a maximum of 7 years. But as we'll see later, it doesn't allow the Oireachtas to set a fixed parliamentary term as opposed to a maximum parliamentary term. This is not a fixed term, it is a maximum term, because we know from elsewhere in the Constitution that the Taoiseach retains the power to advise a dissolution of the Dáil at an earlier point. That's a critical point, and to recap on that, the law provides only for a maximum parliamentary term, not a fixed term. The Dáil may continue up to 5 years and 30 days, but an election may be triggered effectively at any point before that. We know this because of Article 13, Section 2, subsection 1, which says that Dáil Éireann shall be dissolved by the President on the advice of the Taoiseach. Now, it's very important to emphasise that advice here effectively means to instruct. It's a euphemism. Okay, the president, in most circumstances, doesn't have any choice. It's simply a formal ceremonial power, which means that in most circumstances, the Taoiseach has absolute discretion to trigger a snap general election, so to speak, at any point before the expiry of the maximum term. Now, as Eoin O'Malley will explain, I understand, that has a certain effect, we assume at least, on the dynamics of the political system, especially in terms of the influence, the clout, the bargaining power that it gives to the Taoiseach, in the sense that he may threaten or implicitly threaten a snap election as a way of forcing the hands of others, or enhancing his own authority in the political system. So, how is that power limited? Well, why should that power be limited? The power to advise an early general election. And again, I don't want to encroach too much on the next paper, but a limitless or an unlimited power to advise a dissolution might lead to an unbalanced distribution of power and influence in the political system. It might be abused or misused in some way. In particular, a Taoiseach might use the power of dissolution in a bid to retain power to stay in office if he had lost the confidence of the Dáil, or the threat, implied or otherwise, of an early general election may be a way for the Taoiseach to get what he wants vis-a-vis either the Dáil itself or indeed other members of the government, because this isn't a power of the government, it's a power of the Taoiseach individually. Okay? Now, with that in mind, the Constitution does build in a certain very specific limit on the Taoiseach's power to advise a dissolution of the Dáil, and that power lies with the President. Okay, now, even though the phrase isn't used in the Constitution, what the President effectively enjoys is a veto power, a power to veto the calling of an early general election, but that veto power, that power of refusal, only kicks in very limited circumstances, specifically where the Taoiseach has ceased to retain the support of a majority in the Dáil. So where the Dáil, for example, has voted no confidence in the Taoiseach cannot then demand a snap early general election as a bid to maintain power if he is returned to office after the election. The matter then passes into the hands of the President, who we assume is to decide the merits of an early general election in the national interest. And at that point, the President is supposed to represent a non-party figurehead who can make that judgment, so to speak. Okay, now that all sounds very sensible and very attractive, but the way it has worked in practice probably leaves a lot to be desired, because the scope, the parameters of the President's power, the President's veto power, are actually quite ambiguous, more ambiguous than it might seem at first glance. There is a lot of ambiguity concerning exactly when, in what circumstances, this power to refuse the Taoiseach actually kicks in. Okay. Where a Taoiseach is removed by the Dáil, or a Taoiseach is voted, rather the Taoiseach loses the confidence of the Dáil, obviously then the President's power to refuse kicks in. But a government may effectively collapse, and the writing may be on the wall, without that formal vote ever occurring. So the timing is critical, and we don't know exactly at what stage in the political process the President's power kicks in. If you go back to the wording of Article 13, Section 2, there is no definition of the phrase ceasing to retain the support of a majority. Doesn't mean only instances, for example, when the Taoiseach has suffered a formal vote of no confidence. Or might it encompass a scenario, for example, where there has been an effective collapse of a party coalition, where the writing is on the wall, where the defeat or the downfall of the Taoiseach, so to speak, is imminent, but the Dáil has not formally registered its loss of confidence in the Taoiseach. So how do we interpret this phrase in the Constitution? I'm going to call it for shorthand loss of majority support. That's not the phrase used, but that's just the shorthand I'll use. How can the Dáil express a loss of majority support? How can that come about? The most obvious way is a formal vote of no confidence in the Taoiseach or the government, but that's a relatively unusual event. That's actually not usually, as Eoin will explain, how governments fall. It's also understood, based on political practice, based on political convention, that the Taoiseach has lost the support of the Dáil where there is a legislative defeat on a government bill, and specifically a defeat on an issue of confidence or supply. Now, obviously, confidence is covered by an expression of no confidence in a vote. Supply refers to budgetary issues, financial issues, budgetary bills. There isn't actually any strict, hard legal definition of what a confidence and supply issue is. It's not something defined in law at all. It's an unusual area of constitutional law because we don't have definitions from case law of these quite vague terms. Now, there is some guidance from history, from practice, from political convention, so to speak, and what Hogan and White suggest in their textbook on the Irish Constitution is the following, that a defeat on a budgetary issue is clearly a confidence issue. Votes on other matters might be converted into confidence issues by a declaration from the Taoiseach to that effect. And if there is any doubt on the issue, they suggest the government or the Taoiseach can secure a victory, as they say, on an early vote of confidence, thereby avoiding the obligation to resign. But I stress again, we don't have any strict legal definition of what a confidence and supply issue is. And the final point to consider is whether the Taoiseach can be considered to have lost majority support without a formal vote of any kind ever taking place. What is the President entitled to take into account? Could the President regard the Taoiseach as having lost the Dáil's majority support without any relevant vote ever having taken place? What might that mean? For example, the collapse of a party coalition, the announcement of by a minority party that it is to withdraw from government. That is very often what might occur. That, in effect, means the writing is on the wall for the Taoiseach. But the question arises whether or not the presidential power, the presidential veto over the dissolution of the Dáil kicks in at that point. Now, it might seem like an odd thing to suggest that the President could regard the Taoiseach as having lost the support of the majority in the Dáil without the Dáil ever having voted on the matter. It would seem like second-guessing or preempting whether or not the Dáil actually retains confidence in the Taoiseach. However, there is an argument for interpreting the Constitution in that way, because if you were to interpret it as being confined to formal votes, what it would do would be to allow the Taoiseach to preempt the formal vote by requesting a dissolution from the President before that formal vote occurred, but where the writing was already on the wall, where the political landscape, where the lie of the land meant that the Taoiseach faced an imminent defeat in the Dáil. As Hogan and White suggest, it is arguable that the exercise of the presidential discretion to refuse to dissolve the Dáil should not be limited to cases in which a formal vote has been taken. For otherwise, a Taoiseach who had lost the support of a majority could preempt such a vote and insist the President grant a dissolution at that stage. Okay, so is the President allowed to take into account the reality on the ground, so to speak, in deciding whether or not he or she has the power to refuse the Taoiseach's request to dissolve the Dáil? A further ambiguity is what it means to have majority support. Currently, we have a minority government, which seems like an anomaly or a contradiction in terms, because a Taoiseach must retain the support of a majority to stay in office. That's because Article 15 says that all questions shall be determined by a majority of the votes of the members present and voting. In other words, abstentions aren't counted, which means that the leader of a minority government actually does have the support of a majority of those who voted on the relevant votes. So a minority government in some senses is an anomalous phrase. Now, what this means, however, is that in such a scenario, the Taoiseach does have the support of a majority in that sense, a majority excluding abstentions, pardon me. But what Article 15 says is that all questions in each house are determined by that means, whereas this isn't a question in the House, it's a question decided by the President. So is the President entitled to understand that a minority government or the leader of a minority government doesn't have the support of a majority for the purposes of Article 13, Section 2, subsection 1? Okay, that's a relatively minor point, but worth mentioning. Now, this, as I said, is quite an unusual area of constitutional law because whereas constitutional law in general is full of vague phrases that could be interpreted either way, usually we have some kind of guidance from judgments of the superior courts, from the Supreme Court especially, which flesh out the otherwise vague principles and fill in the gaps, so to speak. But we actually don't have any case law. We have nothing to assist us in Ireland as to the meaning or the limits or the scope of the Taoiseach's obligation to resign, for example, or the President's power to refuse the calling of an early general election. Why? Because the Taoiseach, the President's exercise of his or her constitutional powers is exempt from any judicial review. Article 13 makes very clear that the President shall not be answerable to any court for the exercise and performance of the powers and functions of his office, which effectively means that were a President to interpret Article 13 one way or another, strictly or not so strictly, that would be solely up to the President himself or herself. But one of the effects of that is that we have no legal clarification as to what these vague phrases mean. For what it's worth, there is some case law from other jurisdictions, not an awful lot of case law, some relatively obscure case law, it must be admitted, where other courts, for example, the Privy Council, a court relating to the British Commonwealth in this case, suggested that in a similar setup in a province of Nigeria, that the governor who was entitled to take into account events occurring outside of the House itself when deciding whether or not the Premier had lost the support of a majority. In this case, it was the signing of a letter by a majority of the members when the Parliament was out of session. But you could extrapolate from that and say that the President should be entitled to take into account extraneous events occurring in real politics outside any formal vote registered by the Parliament itself. Okay, now, how has the presidential power of refusal or the presidential veto, how has that worked in practice? It has actually never formally been used. Now, there are a number of possible explanations for that. I don't want to encroach too much on the next paper, so I won't go into that. However, the threat or the possibility of the power being used may have been influential in at least one case in 1994. The fact that it has never been formally used doesn't mean that it is useless. The threat or the possibility of the presidential veto being applied might in itself be significant. Okay, now finally, would it be constitutional for the Oireachtas to have a fixed parliamentary term under the current constitution without having a constitutional amendment and therefore a referendum? The short answer is almost certainly no. Why? Because the clear intent of Article 13, Section 2 is to give to the Taoiseach the choice, the discretion to dissolve or to advise the President on the dissolution of the Dáil. Were the Oireachtas simply to pass a fixed-term Parliament Act without first having the Constitution amended, it would, in essence, contradict the existing text of Article 13, Section 2, because it would undercut the power given to the Taoiseach to advise a dissolution of the Dáil. Okay, that's it. I'll be happy to take questions later. Thank you very much for your attention.